All right, good evening, folks. We're going to go ahead and get started. I'm sure all of us don't want to be here 2 or 3 hours tonight, so we're going to try to keep this as brief as humanly possible and as polite as humanly possible. Obviously, all of you are here for a reason, whether it be one way or another, so we ask that you stay civil in these meetings, stay to the point, and stay on fact. Everybody agree with that?
Yes.
Whether you do or not, just please shake your head yes. All right, so we're good. All right. We're going to go ahead and get started this evening. If you haven't signed in and you plan to speak, please sign up there where this gentleman is on the podium. I know that gentleman now. He looks up at me.
Single me out.
Yeah,
How you doing
finally
there?
see you. All right. We're going to go ahead and go over the minutes, and I will take a motion on that.
I've read the minutes. I'll make a motion. We approve the January 2nd, 2025 minutes with correction of the
Yeah, we'll change the
Yes.
McIntyre Charlie to my name on that. So, all right. I have a meaning or a approval. I have a motion for Ms. Barrett. Do I have a second? All right, Janet Holland seconds the motion. All in favor by saying aye.
Aye.
All opposed by the same sign. There are none. Motion carries. If you plan to speak this evening, if you will stand for me, please. Janet seconded, Sonia, yeah. Charlie, if you will swear in these fine folks, that would be wonderful.
You swear affirm the statement you make tonight is the truth to the best of your information and belief?
Yes.
Thank you.
Thank you. You may be seated. Brett?
Okay.
All right. Good evening, everybody. Our first item up this evening is actually old business. It's an application that I believe came through this past November. It was the pleasure of the board to have the applicant go out and obtain some permissions and such for reconsideration of their application. I do have a presentation prepared to kind of recap that if you all would like, just for the benefit of you all. And okay. It's out at Morris Road, 366 Morris Road. The initial request was the variance to reduce the 50-foot building setback to 25 feet along Morris Road there for the construction of a garage. North of Cynthiana Road, accessed by Gunnell, a little over 5 acres or just under 6, however you like to take it, A1 zone. At this time, we are now also recommending approval as the applicant has gone out and gathered the necessary signatures and permissions, things of that nature. A1 zone. Here's an overhead of the property. Just for a little more context, the applicant does propose to put their garage along the southern boundary. As you can see, there's established tree lines, difference in elevation, things of that nature that run central along the property that the applicant has stated kind of forces them to build closer to the road. We'll go ahead and get into this. So when we consider variances, we go by what is called KRS 10243. It's Kentucky State Statute. And basically, whether it be ourselves or the board, recommendations or decisions, for granting variances, we must consider that whether or not the variance will adversely affect the public health, safety, or welfare of the general public, nor will it alter the essential character of the general vicinity, and will not cause a hazard or nuisance to the public, nor will it allow an unreasonable circumvention of the requirements of the zoning regulations. And once we've made these findings, we must establish whether or not the requested variance arises from special circumstances on said property, which do not generally apply elsewhere in the near vicinity or in the same zone, whether or not the strict application of these provisions would deprive the applicant of reasonable use of the land or would create an unnecessary hardship on the applicant. And lastly, whether or not the circumstances are a result of the actions of the applicant taken subsequent to the adoption of said regulations. And somewhat most importantly, the board shall also deny any request for a variance arising from circumstances that are the result of willful violations or actions of the applicant of the zoning regulations by the applicant subsequent to the adoption of said regulations from which relief is sought. So, this is the initial proposal as brought in this past November from the applicant. I've highlighted there in yellow that the easement that's also the building line easement across Morris Road there at the southern boundary also constitutes a utility easement. At that time, staff was not able to recommend approval as we cannot authorize encroachment into utility easements that are designated especially to specific utilities. The red box there you see at the time was the proposed location of the garage approximately. The applicant was instructed to, the application was continued until such time that the board thought that they could come back with some approvals and permissions, things of that nature. I've been in pretty well constant contact with the applicant, and it has now become the case that they've got enough to come back for consideration. I pretty well just went all over all that, so we'll skip that. So it did not reproduce very well for the packet, so I would just blow it up for the presentation. The box now for the garage is a little bit further west of the curve. Last time we were here with this application, it was a point of concern that placing a structure in kind of in or near that curve could be a danger to passersby and vehicles, things of that nature. Potential people coming off the road hitting the structure, line of sight issues, things of that nature. So the applicant has proposed to pull the structure back away from the curb at this time, and I'll let them speak more to that. So our general findings are that the parcel is just under 6 acres and is zoned A1. The setback the applicant seeks to encroach upon also does comprise a public utility easement, and the applicant has now provided the sufficient permissions from the appropriate utility providers to allow reconsideration, and the applicant has also proposed a new location for the structure. The applicant is here if you have any further questions or clarification or anything for them, but again, we do overall recommend approval at this time.
Okay, any questions for Rhett? Okay, applicant is here. You want to say anything?
I think he covered it really awesome.
You remember the last meeting, don't you?
Yes.
All right.
My heart is racing.
Mine too. Mr. Chair,
Yeah.
can
Go
I ask
ahead.
Brett a question? Did you say it was pulled back, or it's still the same 25 feet?
When I'll let the applicant speak, but it's still going to encroach upon the easement, still about 25 feet.
It's just moved to the west? but
Yes.
It's still the same encroachment?
Yes, sir, yes, to, hold it back away from the curve. If the applicant is okay with that being the terms, okay, as approved.
From the curb, not from the road.
Not the curve, not the curb. Yes, sir.
Thank you.
Any questions for Rhett or the applicant?
So, yeah, the drawing, so it shows it's closer to the thing. It's not closer, that's just the drawing.
It moved
It's not
west.
closer to the road.
Just didn't overlap it, that's
Yeah.
fine. Okay,
Yeah, it's like within, like 25 feet within that 50-foot easement.
okay, so the encroachment still stays the same?
Yes, sir.
Okay, all right. All right, are any of the neighbors here on this one, or anybody that would like to speak on this one? Wow.
Have you heard from any of the neighbors, Rhett, since she spoke with the neighbors and they came up with this new?
No, and we did re-notify.
good.
I don't know that I had a single phone call or anything. I know at the time in November, it was also asked that people decide to be good neighbors, get to know each other, things of that nature. Seems like it's
can I
gone a
ask
long
you a
way.
question? Did you speak with some of the neighbors?
As soon as we left out of here, we spoke. I just told them, I was like, listen, we're a family that's just trying to live our lives on our property that we just bought, and we just wanna, we did have a friendly conversation, so I'm hoping that's why they're not here tonight, but
Well.
we will.
They may be out with torches tonight, though, so just,
Hopefully not.
Thank you, Charlie, appreciate that.
It's a good thing we're not just there on the property yet, right?
All right, so good, this one does my heart good then. I've been accused of being a bit heartless at times. On the other hand, you tugged at my heartstrings that night, so you win. So I'm gonna make the motion that we approve application S-2024-42, taking into account the staff recommendations.
I was thinking,
Sonia Barrett seconds the motion. Any questions or comments? All in favor by saying aye? Aye. All opposed by the same? There are none, motion carries.
Okay.
Rhett will get you the information you need. You're welcome to stay through more punishment if you would like, or you can leave. It's up to you all. So,
I'll get you an email over for building inspection stuff tomorrow, okay? You're very welcome. On to our first item of new business for this evening, case number 5 of the new year. We're actually moving out past Stamping Ground to Wood Lake Road here, 2101. The request under consideration is 2 parts. The first is a variance to reduce the western side yard setback from 50 feet to 7.5 feet, rather, for the construction of a home, and also to go along with that, they would like some relief from the lot width building line restriction from 250 feet to approximately 210 for the location of said home, to abide also by the 50-foot front yard setback that's standard in an A1 zone. Access to this is off Stamping Ground Road, north of Pea Ridge, west outside of city limits, right at 5 acres. Currently, staff is recommending denial of the variance to reduce the side yard setback, yet approval to provide relief from the lot width restrictions. Here is the parcel confirming the zone, and a general overhead of the parcel as well. And we've gone over the language for variances. so just to go back in time, this is the property as it existed back in 2007 during a division. Zoomed in a little bit here, and I kind of doodled in some red dashed lines to show where it was created from, but it was not created then, okay? So that would be the parcel as it is today, but on a previous plat. I'd also like to note that green elbow up there is an access easement that was created through this plat. It's recorded as a 20-foot, I believe, permanent access easement. There's some further language here regarding said easement, of which tracts will and will not benefit from it. And then most recently, this tract was divided all the way down to 5 acres in 2024. And again, this green line here denotes the easement as it exists and as it's recorded. It serves the lot to the northwest as well as the parcel itself. That more substantial dotted line that kind of bisects the property, you know, west to east, is an AT&T utility easement. The green line, as you see, kind of overlays over top of that easement. That's at which the point the access cuts into that parcel, as denoted and recorded on the plat. A little closer. This one was actually provided by the applicant, and I doodled on a little bit there. The red box towards the front of the parcel at the frontage is the proposed location of the home. As you can see clearly, it's below the front setback line, which would accommodate the standard mandated lot width. The orange box there is what denotes the platted buildable area, the orange dashed lines there. As you can see, this house is both south and west outside of said area. The red box here is an approximate location of the home. The applicant's welcome to correct me, but I didn't really have accurate scale dimensions, but I just wanted to give an overview of what topographical information is available to us in office. It's provided by, you know, the United States Geographical Survey Society, et cetera, whatever the acronym may be. But as you can see, the slope is consistent from, you know, west to east and north on the property. The green foliage there, as well as the closer contour V area, does denote a drainage area that is noted on the plat. So it does slightly increase the further you go back on the lot. Overall, it is fairly consistent. It was staff's conclusion at this time, given the consistent slope as we are able to see in office, that while, you know, granting relief from the lot width at the front to allow the home be built closer to the road within the 50-foot setback as standard by zone, moving the house all the way to the west did not actually grant any relief from the slope as it exists, as we're able to see. This is an expanded overview just to exhibit that the slope is pretty well consistent throughout the area. Wood Lake Road in general, you know, kind of has its ups and downs very literally. So, you know, the topography amongst all of the adjoining properties is very similar. It's probably hard to see from your vantage point, but there are different houses denoted on there. What probably looks like rectangles to you are the address numbers. So you can kind of see the placement on similar topography throughout the area. And I just wanted to kind of pull up and show, you know, similar variance cases and requests from the area. The nearest location was one that was requested and approved in 2000. Just across the road, it was also a variance request to reduce the minimum lot width. So while other variances do not provide precedence, and it should not be mistaken as such, context is somewhat important. I did look back all the way to 1986 at different cases along Wood Lake Road. Most of them dimensional variances were either minimum lot width or side yard or front or rear yard setbacks for accessory structures that were granted. Overall, we have found that the proposed home would be located approximately 7.5 feet from the western property line while adhering to the 50-foot front yard setback. A1 zone has standard 50-foot setback requirements. Allowing construction of a home at the 50-foot front yard setback would establish a lot width of approximately 210 feet at this location. The applicant has provided justification for their request, and I have also under the understanding they'd like to give a little presentation, which we're able to accommodate as well. While the proposed building site is somewhat flatter than much of the parcel, it's pretty well consistent throughout the parcel as well as the rest of the general vicinity, so the conditions exist on site and elsewhere to a similar degree. Establishing the building site further from the western property line, again, potentially could not significantly alter the slope from one place to another. If the home is allowed to adhere to the standard 50-foot front yard setback, it would still gain them some flexibility while also maintaining the character of the area while adhering to a zone standard setback in the front. Staff has also concluded that a 7.5-foot side yard allowance is reflective of an urban standard. In our R2 zone, that's our medium density residential urban use zone, we do allow a standard of 7.5-foot side yards. When we set these standards in our zoning ordinance and our schedule of dimensional regulations, we set the standard for how we would like a zone to appear, with a balance of safety, separation, privacy, function, consistent character throughout the area. As such, the 50-foot side yard setbacks and front and rear are, established for the same reasons: safety, separation, consistency of area, and character. So conversely, however, allowing the construction to occur closer to the front line would still retain the character of the area as it would be 50 foot or more off the road. It should also be noted that proposed home location is well south of the entrance point as noted on the plat. Access point is detailed as approximately about 130 feet or so into the property along the west property line, just beyond, the aforementioned AT&T easement. So with our two-part application here, staff again recommends denial of the side yard variance request, but however, approval of the front yard allowance, to allow them to be 50 feet off the front property line with relief from the minimum lot width of 250 feet. And while I pretty well have our standard conditions of approval here, I have also added some on the back end. I've amended condition number 5 that you received in the packet. While Wood Lake Road is under state jurisdiction and, they would need approval from the state for a new entrance, it should also be required that we would need a new plat to review and record at said time of new entrance is established. That way it is legal record. And also access onto the parcel that differs from the easement as notated on the plat, even if it's not a new entrance onto Wood Lake, should also require a new plat for review and recording, since it's going to differ from the current legal document.
Rick, can you go back to the topographic?
Yes. Big one or little one?
Well, big one if you I'm starting to get to that age where I can't see the little one. No, but it's not going to affect anybody this side of it because there's a road there. So,
That's the driveway that pulled up, right, and it drops there, it's flat.
all right, thank you. Anybody else have any questions for Rhett?
Not yet.
All right,
Okay, that's
thank
fair.
you. Appreciate it.
The applicant is here. Again, we are able to provide accommodations for them to present. I believe you all have also seen an email summary and attachments from the applicant.
Okay.
If they would like to present, they're still able to.
The applicant?
At
Sorry,
such
I
time,
didn't
I'll
know who I
yield
was
to them.
talking to, but that works.
If you give me just a second, it's PowerPoint, right on this? Yeah. Give me just a moment.
Or I can just talk at y'all.
Do a laser pointer? I don't know, I never use it.
Oh, I thought, oh, it's fine. I don't need a laser pointer. I got a finger. Oh, we got that. Look at that. Oh, this is fancy. All right. Thank you, Elise. Thanks, Rhett. Thank you, members of the board. Yeah, my name's Michael Barnett. I'm the applicant on this, although it's not, the land is not presently titled in mine or my wife's name, it's my wife's grandparents' deed and over. Anybody read my 8-page little document? To purloin a witticism from Mark Twain, I would have written you a shorter one, but I didn't have the time.
Yeah, thank you for that. Appreciate that.
If you didn't, I'll, run you through it real quick and not waste too much of the board's time. With respect to the topo map and overhead, I think everything is true, sense correct. The general proposed location of the house is here. There is an existing driveway here, curves all the way back to grandparents' house up here. There is an access easement, but the access point to the new house can be a new driveway on Wood Lake Road. We've already gotten approved by Transportation Cabinet. I have no qualms with any conditions that the board seeks to put on this approval vis-a-vis that replatting. As far as the topo map, I mean, I just rough did this little pentagon by hand, but you can see, I mean, each one of these topo lines is 10 feet of drop off. So starting from the road, it's 10 feet, then 20, then 30, then 40, then 50, all the way down that hill towards the northeast. I got these cute little video walkthroughs without wasting too much time. This is about 20 seconds. Control point? Oh shoot, what have I done? There we go.
There you got it on the laptop.
Yeah, it didn't want to work on here. Well, never mind. I ain't gonna fuss with it if it ain't gonna show.
Has the board been able to see this?
I watched them on,
videos, yeah.
yeah.
Okay.
Did you watch it?
Well, forget videos if they don't work. Which I'm, happy to come back and play them again next month or refer you all to your email. You want, thank you, Ms. Barrett. They, basically, the only reason I took those videos is to show the lay of the land. As you walk up on the front of the property, you'll click, now this isn't even on the property, this is taken from the parcel to the west. These orange stakes were placed to mark the western property boundary. And so up here at the front, you get flat. And very quickly in that back field there starts to drop off down to 8 foot. And I took this one all the way, from looking at the bottom of the hill, because you can see my truck way up there, actually his truck. It's a long, steep walk. All we're asking here is to be able to build this house basically as far west and south as we can, because that's what Mr. Haddock's, the builder, told us you have to do. Otherwise, it might be prohibitively expensive to try to cut into that slope. The closest neighbor is David and Jean Carroll Vest down at the southeast. Because we're asking to push to a 7.5 foot western side yard, this would actually build the house further away from the nearest neighbor and maintain as best as we could the character of the A1 zone. Looking out west, so I understand a 50-foot side yard variance within the A1 zoning ordinance, or not a variance, a 50-foot side yard restriction is gonna require that there's at least 100 feet between two adjoining structures. Well, we're already 500 feet from the Vest house. And if you look out of the west out here from the, looking at the adjoining parcel, arguably the way that driveway, which is easement protected, already sits through the land, the way there's a, drainage culvert filled with trees right there, I don't think it's possible to ever build another structure within 50 feet of that, especially if you go to the overhead, the narrowness of that adjoining tract. So even if you had 150 or 250 foot minimum width build line, put you somewhere back here, 50 foot minimum side yard, if you're gonna build another house on that adjoining tract someday in the far flung future, it's gonna be more than 100 feet from the house that we're proposing anyway. Even if you see fit to grant the 7.5 foot side yard. I guess that's my last slide. So pretty much like I wrote, I agree with the fine work of the Planning Commission staff that the slope is relatively consistent towards the north and the east. I think that kind of cuts in favor of granting the variance in this case. I mean, that's exactly the problem. As soon as you get past 50 feet in that top flat part of the hill, it starts to consistently drop off. I asked for 7.5 feet because I understand that that's, that's something the Board of Adjustment and the Planning Commission are typical working with within subdivisions, et cetera, more urban areas. I understand that the staff report says that that's not appropriate for an A1 zone side yard. Respectfully, I don't know that appropriateness of that to the particular zoning ordinance is one of the concerns that this board is charged to address under the statute. KRS 100.243, I'd argue that we meet all the bullet points there, granting this variance to allow this house not to be prohibitively expensive to build into the hill. It wouldn't adversely affect public health, safety, or welfare. It wouldn't alter the essential character of the general vicinity. The house is just as far from the road as any other house, still gonna have a 50-foot front yard. gonna be even further from the nearest neighbors, not gonna be butting up on the existing easement-protected driveway from Grandma's house. It does not, it arises from special circumstances, which don't generally apply to the other lots around. Strict application of this 50-foot side yard requirement would deprive us of reasonable use of the plant and create an unnecessary hardship. And obviously, this isn't a result of our willful violation. There's been no earlier application or replatting of the land. You know, I made some reference on the last page of my little, statement here to the last couple of Scott County side yard variance applications that this board heard at last month's meeting. Heck, and the one that we just heard in old business for 366 Morris Road, all approved. And this is basically exactly the same, right? On the Miners Branch Road from last month, the board found and planning staff found in favor of approval, reducing a side yard required setback from 50 feet to 15 feet because topography otherwise inhibits construction on other areas of the property. There are established trees and wood lines along the eastern front and the western front between any adjoining houses, so it's not going to impact privacy. It's not going to impact the character. If the board has any questions, I would love to answer.
I got a few.
Please.
You mentioned hardship. What hardship does this create if we go into 15 feet, if we go into 30 feet? What is the actual hardship that it creates?
My understanding, so I've only been out there physically with the builder. I'm not a surveyor, I'm not a builder, I'm not an architect. Our understanding from talking to Mr. Haddix, and he sends his regrets, he's out of the country today or something, but he said he couldn't be here. My understanding is it needs to be as close as possible to the western edge, because as soon as you get 15 feet, 30 feet, anywhere near that 50 feet ordinary western side yard setback, you're so far down the hill that the slope, whether it's a consistent slope or not, it's going to add to construction cost. We just want to build up where it's flatter, and basically the backyard's going to immediately start dropping off, but.
Okay, so the hardship, is it more of a financial hardship? It'll create more cost?
Correct.
Correct? Okay, all right. I'm going to ask a question. I don't think staff had the chance to go out there. Is that correct?
Not physically, no, sir.
Okay. And Paul Haddix is not in the country right now either, correct?
It might be in the country. He said he was out of town or something.
We're all
I
familiar
can't-
with Paul Haddix, so it's hard to say where Paul's at. So, okay. All right, Sonia?
I had a question for staff. So, I understand, we all know, it's Scott County, that the greater the slope, the more the cost. We've probably all absorbed that ourselves, building houses, I know I have. So, he's saying more of a hardship when you get to the next curve or the next curve. How is that comparing to the hardship of people saying Mallard Point? Is this any steeper than what they consistently build on? It's no worse than that, right? It looked to me like it was flatter than that.
Staff can't
Can't do
definitively
that.
say on the fly
Yeah.
conditions of one property to another, but if staff or the board would like to take those sort of things into consideration, that's fine. I'm just not. prepared
Okay,
to.
it just didn't look like any greater hardship than what we see all the time, is what I think.
If I may, I think again, where staff sits on that point again is in the KRS subsection A there, is the request for variance arises from special circumstances which do not generally apply to land in the general vicinity. I think as we demonstrated with the overall topo map of the area, whether it's on the parcel or elsewhere in adjacent properties, the rolling nature of those hills is pretty consistent throughout. And again, staff wants to be very clear that what we're really talking about is that if we're granting a variance, we don't want it to be an unreasonable circumvention of our zoning code.
Correct.
So that's why we want to be very clear that it's not that we don't understand that there should be some consideration given to allow for the buildability of the parcel, rather that, and the word was used, it's not appropriate. And I think that speaks against more to the character side at 7.5 feet. And so unreasonable, and then also just is it the least amount of variance needed to accomplish the goal of the applicant. The
And
other
I agree
thing
with that point.
that we would just also like to point out is the applicant. You did mention that is it your father and it's your in-laws property? Grandfather.
In-law.
Okay. Well, correct me if I'm wrong, but were they the ones who brought about the subdivision in 2024 that created that lot?
No, that was, well, there was I believe when they bought the property in 2007, it was already 2 tracks. It's 1 and 1C or something. Their plan, that 1C is 10 acres, and Ms. Katz helped us with the, planning commission or not helped us, but we, went through planning commission, replatted. Because that was 10 acres and an A1 zone, or A1 plat or parcel has to be minimum 5, they're going to give 5 acres to my wife's lovely parents and 5 acres, who will then in turn deed 5 acres to us. So, what the intent is, 2 5-acre lots. We accomplished the subdivision last year with that intent.
Yeah, and so staff's concern would be that as you made the shape of the parcels, should be then deeded, that there is a concern that you have created the lot sizes yourself, which is just a concern that staff has.
Okay. I understand. I mean, in response to that, I guess I would offer that it was the cleanest way to do it because there was already an existing 10-acre parcel, and I didn't understand that, I guess zoning ordinances at the time that we decided to do this that way, that we would have to build 50 feet over to the east was going to create a hardship. I mean, there's a outside possibility we could just get it replatted again and reshaped, essentially, move some acreage off the north to move it to the west so we could build the house where it needs to be.
Staff would be favorable to that.
Problem is that takes another survey, another journey down to every utility to get signatures on a new plat. And I mean, we've been at this for 3 years now since we've attempted to start building this house. This is almost the last step in this odyssey. If we have to re-subdivide just to adhere to the 50-foot side yard issue to fix this, the house would, we just barely reshape and push 50 more feet to the west. That sounds like an unreasonable, possibly, choice as to why to replat, when it would be easier for the Board of Adjustment just to grant the variance in this one case, keep the plat as it is.
Understand your point, but being easy for the Board of Adjustments has never been in our repertoire, unfortunately. Nothing's ever easy, and I agree with Holden and his point as well, that a hardship has to be proven, right? I couldn't build a basement in my house, for instance, because it cost me $55,000 extra. That's not a hardship, it just means I can't build a basement, right? So a hardship has to be something that prevents you from building the house completely. That's a hardship. Now, I will say, I am a tad bit, I'm not disappointed, I don't mean that in that word, but the staff didn't go out and physically look at the property. That would have been helpful on that point, to say that. What I will say is I don't personally feel I have enough information to make a decision here, because Mr. Haddix is not here. Staff has not looked at the property. We've got our other job is to make sure that that neighbor to you, although it might be family now, it may not be in 40 years.
Correct.
So whoever buys that is going to be looking at you 7.5 feet from their property line, right? So I get what everybody says, you can't build there. We don't know that. We don't have enough information. So that's what I'm having a hard time dealing with right now, is we've got some ambiguities that's not complete, right? And if it is, you have to go out and plat another building or another property line, then that may be what has to happen. And I hate to tell you that, but understand where we're coming from. Just to grant a variance at 7.5 feet is difficult for us when we don't know for sure if there's a hardship or not, right? Does that make sense?
Absolutely.
Okay.
And I wouldn't ask you to make that factual finding without sufficient information. If we need to continue this to next month's docket, have Mr. Haddix here, if I need to have a, pen and stake survey done again, we could do that. This is what I'm able to accomplish having gotten staff report 3 days ago.
Then
Charlie, can you shed some light on this? What's your take on this?
Well, unfortunately, I agree with Holden. I agree with the chair's questions. And I certainly agree with, I wouldn't want to incur some of those extra expenses too. Extra expense as a general rule is not something we really deal with. It is if it requires the house, to not be built, or it's going to greatly reduce, something, kind of outlandish. Merely the fact that it costs you, a few thousand extra, that's really not something we should be doing, I don't believe. It bothers me, although it encourages me both, when he says, well, we could reconfigure the lots. I hate to have that odyssey continue for them, I admit. But on the other hand, if they can reconfigure the lots, suddenly there is no need for side yard variances. There's just, and of course, we're not supposed to do this if it can be done, can be accomplished without a variance. Well, if they can, do another survey and reconfigure the lot so that they don't need that, or they don't need one so severe as down to 7.5 feet, then I think that's really a bona fide alternative for us. And we have, in fact, given, where, including in Mallard Point and including, well, not far from this road anyway, where there was really a dramatic, and we allowed a pretty significant, I'm not sure about a 7.5 footer. That's a downtown, or I'm sorry, an urban setback. But we have allowed them relatively significant, maybe cut in half or something. But I don't think we've ever done one quite an urban level, way out in the county. But anyway, as long as they can redo the survey and reconfigure, it's really kind of hard for us to say, yep, we're gonna give you the greatest variance we've ever granted. I mean,
Right.
that's a little much.
Can I just go ahead and make a motion?
I mean, as to the greatest variance, I don't know what, the Board of Adjustment has done for 50 years. I know that last month you granted one from 50 to 15 feet. In the old business, we granted one for, I think it was 50 to 15 feet. If the board would see fit to change to a 15 feet variance, I'm sure that 7.5 feet ain't gonna break the bank, but the 37.5 feet apparently will. Or rather, 42.5 feet.
We're not going to go back and forth on this. Here's what I'm going to do. I'm going to make a motion that we continue this to the next meeting. I am going to ask a couple things from you. Okay? As the applicant, I'm going to ask that you meet with Holden and staff before the next meeting, find out the best course of action. If the best course of action is in 7.5 feet, in your opinion, then that's fine. But I'm also going to ask that a firm reason be stated as to why 7.5 feet is the number.
Sure.
Does that make sense? All right, so I'll make the motion to continue under those recommendations.
I'll second.
Janet seconds the motion. Any questions or comments? All in favor by saying aye.
Aye.
All opposed by the same. There are none. That motion carries.
Thank you.
Thanks.
Can I get a card? Yeah. And that concludes our business for the board. May we be excused?
Thank you.
Thank you all.
We should be seeing you again soon.
Yeah.
Right. Yeah, exactly. No, I know. All right, Rhett.
Ready,
On.
steady?
Ready, steady.
Yeah. You guys are doing great.
Just keep that going, remember
Yeah,
that. All right.
Okay, let's go to a different part of the county. About 2897 Cynthiana Road. This is a conditional use permit for a secondary residence for either a family member or farm worker. Again, we're in the A1 zone, just east of Newtown, 38 acres and change. Overall recommendation is approval. Here's the parcel in question. Little overhead here. As you see, the existing structures there on the northern side. And the applicant has provided us one of the better drawings I've had in recent time, and I appreciate it. So it's a very detailed drawing here of the conditions as they exist on the lot. You see the kind of U-shaped driveway there with some offshoot branches. The green box that I've inserted and overlaid on their drawing is the proposed location of the new structure. It would be located, with use of access to the existing drive and other structures, things of that nature. Being, 38 acres and change, this parcel is well within its rights to apply for secondary residence, as we require a density of one dwelling unit for every 5 acres, and there's just one residence on the property currently. Positioning accommodates all required setbacks. It's well more than 50 feet from all the property lines. Well, kind of going backwards here a little bit. So our zoning ordinance does list secondary single-family residences as a conditional use in the A1 zone. The applicant has stated that the house will be located about 180 feet from the western property line and 150 feet from the front, well away from the eastern and the southern. This runs along US 62, has an established driveway that both residents will share. And again, it satisfies all the setback requirements as set forth by the zone. Here's our general findings. Again, project site is just over 38 acres. Schedule of, probably should say zoning ordinance there. An A1 zone allows for one dwelling unit for every 5 acres on a given parcel. Being over 38 acres and change with just one residence, it's well within its density allowances to request a secondary residence subject to approval. And it does accommodate by all the 50-foot setbacks, and approval of this conditional use permit would not sacrifice the health, safety, or welfare of the surrounding community. nor alter the character. Again, we recommend approval with, all of our standard conditions of approval here. I will note, on the drawing, it did show this structure a little closer than 100 feet from a barn or something of that nature. Typically, we request or require that all structures are separated by 100 feet to accommodate, new division lines, if they so do occur, to eliminate the need for any variances in the future as setback encroachments on new parcel lines. I would make that recommendation to the applicant. If they can accommodate that, that would be stellar. But I will let them speak to all those facts.
Okay, any questions for Rhett? Is the applicant here this evening? Anything you want to add, sir?
No, he's done an excellent job.
We think so too. Anybody else want to add anything to this application?
Did he do the extra 100? Did he fulfill that? Yeah.
Yeah, I guess that is a good question. You want to ask that? Can you step up to the podium for us, please? I'm sorry. We have one question.
Yes.
Red had spoken to the 100-foot setback from the barn to that house. Could you accommodate that?
I don't see why not. I originally placed the house tentatively. I mean, if I have to move it 14 feet or something, it's no big deal.
Okay.
Okay.
So, I mean,
That was the easiest question we had tonight. All right,
Okay.
good.
probably will
All right.
be, yeah.
Anything else to add from anybody on this? All right, if not, I will entertain a motion.
Charlie, you okay with everything?
Yes, yes, I am.
I'll make a motion that we approve application S 2025-06 for the secondary residence at 2897 Cynthiana Road, taking into account the staff recommendations, adding the condition that it makes the 100-foot distance.
It's included.
Is it? Okay.
Yes, ma'am, I just wanted to highlight it.
Okay,
Okay.
thank you.
Ms. Barrett makes the motion. Do I have a second? Ms.
I'll
Holland
second.
seconds the motion. Sorry, Tommy, you're 2 seconds too late. Any questions or comments? All in favor by saying aye. Aye. All opposed by the same. There are none. Motion carries. All right, Rhett, you're back up again.
Wasn't much of a break, but that's okay. Our last new business application of the night, I believe that's correct. We're out 1580 Bond Pike. This is a variance to reduce the minimum lot width at the building line from 250 feet to 190 feet for construction of a home. Again, this is out Owenton Road, little east and north of Stamping Ground city limits. Parcel is right at 25 acres, A1 zone. Overall recommend approval. Now, this application is a little different. The applicant has come to us after having taken multiple steps through the building process. From my understanding, and I'll let them clarify, that they'd begun the construction process, sought various permits through the city and other jurisdictions, and they were told, need to go to this permit office, go to this permit office, and by the time they got to building inspection, they were like, well, you don't have a building permit, and you also need to talk to planning and zoning because of your home location. I'll let them speak more to those issues. So this is what I, lovingly refer to as a posthumous variance request, where staff finds it necessary to bring a property into compliance through this process, where there may not be any public benefit, for substantial remediation of the situation. So this is the parcel before it was divided off in 2003. Again, I've kind of located it here on the parcel as it will come to exist. This is the property now. As you can see, the bottleneck there is where the applicant has located the home. It's adjacent to some other existing structures. There's an existing drive there as well. This is a zoom in of the most recent plat. The green dotted lines there denote what the surveyor had established as the buildable area. That's not only 50 feet from the property lines, but also accommodates what is our standard minimum lot width of 250 feet. While the home placement is currently more than 50 feet from all property lines, the area that the person has chosen is not 250 feet wide. I'll let the applicant kind of clarify more to those concerns. This is a rough estimation of the home placement dimensions as they stand. I've had multiple conversations with the applicant, kind of trying to see the best way forward, see where we're at, see how things stand. At the front of the house, the lot is approximately 228 feet wide. At the rear, just under 200 feet. And again, all the nearest corners are more than 50 feet from the adjacent property lines. This is just a concern of the lot width at the building area. So again, we have stated, and I'll let the applicant clarify, that there was some confusion and misunderstanding throughout the construction process, which has brought us here. The plat does denote the buildable area, and it was identified on a survey. I'll let the applicant elucidate on that. It's located within that bottleneck, about 700 feet or so from the frontage of Bond Pike, long existing driveway near some adjoining structures. And though the home is not compliant with the minimum lot width standards, staff feels that it's appropriate to bring the property into compliance through our variance process, as the structure is under construction and or under roof. It's my understanding that, mechanicals are essentially ready to go into the structure, and that permitting process and the waterfall kind of led us here. So it is a 25-acre A1 parcel, and I've already kind of spoke to the statistics regarding the home site and its placement. At this time, it is staff's recommendation that we do bring the property into compliance through an approval, just to get everything square and on the record. That way, they can complete their building process with the proper permits and permissions from us. And yes, that's where we're at. All of our conditions of approval are standard with no additional. As you'll note in here, our conditions of approval do state that they shall provide copies of building permits and things to us as a condition. But beyond that, I have nothing else to add. I believe the applicant is here.
Okay, anything for Rhett? All right, applicant want to add anything? All right, you agree with all that, huh?
Yes, sir.
You're just ready to get out of here, aren't you?
Not really, but.
We are. All right. I don't think we have anything to add, Rhett. I'll make a motion that we approve S-2025-07, taking into account the staff recommendations. Tommy seconds the motion. Any questions or comments? All in favor saying aye. All opposed by the same. There are none. Motion carries.
There may be some copper left on my seat.
Thank you.
That concludes all of the new business for the evening, unless there's any further questions or anything. Okay, then I will yield my post.
Thanks, Rhett.
Thank you all. I appreciate it. It's always a pleasure.
Pleasure.
Now we know he's lying.
Yeah, now we know he's lying. That's right.
He just
It
smiled.
wasn't a
He just
pleasure.
confirmed it.
Yeah.
I won't have to go to that short trip to a room meeting like this for.
Yeah, there you go.
Okay. Board members, our next item is a public hearing regarding conditional use permit S-2022-47. This is for the Turf Masters Quality Landscapes, Adam Franklin. The recipient of that conditional use permit is here. I'm going to do just.
Holden, before you go any farther,
Yes.
just let me ask a clerical area. Charlie, do we need to close one meeting and go into a public hearing?
You need to announce that we're going into it.
Sorry,
Into
Holden.
the public hearing.
I just want to make sure that everybody's aware that we are entering into the public hearing section of this. Sorry, Holden, go ahead.
So staff would like to provide a quick timeline of events, and then essentially summarize recent activity, and then open it up for both the applicant and the public to present testimony. So going back to 2022, the applicant, Adam Franklin, received a conditional use permit to begin operating a landscaping business at 2461 Frankfurt Road. As a part of that application, the conditional use was granted with 12 conditions of approval. Following that conditional use permit, Mr. Franklin did apply for a preliminary development plan that then led into a final development plan. It was very shortly after the granting of that final development plan that we received complaints related to the operation of the landscaping business, as well as concerns that all 12 conditions of the permit were not being met. This board conducted a hearing that was in August of 2023, and out of that was an indication that the plantings necessary as one of the conditions needed to be put in place by October 31st, 2023, and at the same time, concerns were brought up about the potential of burning of material on site and the negative impacts that was having on the surrounding community. And it was agreed upon essentially to have limited burning to reduce the amount of vegetation that was currently on site, and then cease any burning. Also, at the same time, it was made clear that there could be no storage of materials in the floodplain. Since then, a significant amount of time has passed. However, we did receive additional complaints earlier this year related to, again, the operations at 2461 Frankfurt Road and concerns that the conditions were not being made. That was brought before the board, and the board made a determination to ask for a zoning complaint investigation / cease and desist for Turf Masters Quality Landscapes. At that time, staff then sent a letter to the applicant, essentially stating that all corrective action needed to be taken by January 10th of 2025, or we'd be here at this hearing today. Staff did not have an opportunity to make contact with the applicant before January 10th, and unfortunately, very little communication was had in that interim period. That brings us up until Tuesday of this week. Tuesday of this week, Mr. Franklin came into our office. We had tried to schedule a time before. Unfortunately, that had fallen through. Mr. Franklin, I will also say, did try to come into the office at some point in December, but unfortunately, I was at another meeting and I was unable to talk with him at the time. But he did come in Tuesday. He informed me that he's been working to make sure that he is in compliance with all of his conditions. He invited me to make a site visit out to his site, and so I would like to just talk about the site visit that was conducted yesterday for just a moment. The short of it is, it's very obvious that Mr. Franklin is making efforts to come into compliance with this permit. Staff in visiting the site did not see any evidence of storage of materials in the floodplain. Staff was made aware of various plantings in line with the preliminary development plan and final development plan that had been put in by the applicant to help work as a landscaping buffer. Staff was also really encouraged to hear that the deficiencies that were identified, and you should have a copy of an email that was sent basically following up on it, that the deficiencies that were identified, Mr. Franklin is in full agreement that he can and will be in compliance in the relatively near future. And so what staff is recommending at this time is to allow the applicant another 90 days to come into total compliance, with a progress report to be conducted at the next hearing of this board to show immediate results. Staff would also like to see a voluntary compliance agreement entered into by the applicant that again puts in writing all that is to be accomplished in this near-term window. Ultimately, and I want to be very clear about this, it's not our intention to put a small business out of business. Our intention is to get compliance. And we believe all the way back into 2022, when this conditional use permit was approved, that if all 12 conditions could be met, then this is a good fit for the area. Obviously, we share the community and this board's concerns that without those conditions being met, that is not taking place right now, and that there are adverse effects that are being felt in the surrounding neighborhoods or adjoining properties. So with that, I would like to step back and allow for the community or the applicant to speak. Any questions before I do that?
I don't think we have any of you right now. We want to do this in an orderly fashion. We've done this before. We're all familiar with each other. So if this gets out of hand, I'll ask for everybody to be seated again, and we'll go from there. All right, we will speak one-on-one. I ask you not to address each other. Please don't do that to me. Don't make me stop that. But I ask you to address facts only. If we've already said one thing, there is no opportunity to beat a dead horse. Make sense? So we don't need to hear it again. So Mr. Franklin, I'm going to ask for you to step up first. Anything you want to tell us?
He said it exactly. I want to come into compliance. It's going to be easily able to do. I think it will take less than 90 days. He summed it up perfectly.
I'm going to reserve the right to come back to you.
Can
in a
I
minute.
ask him a question?
By all means.
I do have a question, because you said it would be easy to do. Why has it not been done?
Part of it was the snow that we got when it came in.
Well, I mean, back to 2022. You were given the conditions with the original conditional use permit.
Was I out of compliance in 2022?
Well, you were given the things to become compliant with, and that's not happened. That's why I'm asking. The plantings and all the, out of the flood zone and the vegetation removed.
Yeah, the plantings have been there. It's the vegetation,
Okay.
to removal. I've been in contact with Rumpke to be able to get dumpsters out there to get this cleaned up. And going forward, I've already talked to Rumpke, and every time we do have accumulate waste, like other landscape businesses do, we're just gonna take it straight there.
Okay.
Not back to
Thank
our
you.
property.
We'll reserve the right.
Yes, thank you.
All right. I know there are plenty of opinions, right? So, where do we start? Who wants to go first? Do me a favor,
So
please
I am
state your name and your address.
Kristen Chilton. I live at
Excuse me,
280
Kristen
Chilton.
Chilton? Thank you.
Yes. And I live at 280 Robinson Lane, which is all the way at the end of the road, right across from the spillway. And I do want to say that, commend him, that when he bought the property, he did go in there and put new fencing in, fixed up the building, and it did look, it had been improved. I will say that. We have no intentions of running a small business out of business. That is not my concern. My concern, I don't live next to him, so my primary concern is I live in the flood zone and I live across from the spillway, and if you go there today, with the water being slightly up, there's lots and lots of debris that's just coming down the roadway. And with the piles of debris that he had at one time stacked in the floodplain, if the water comes up, which I know he probably doesn't believe because he's not lived there, would be all over the road, all up around our house, because that's just what it does. And it's, you know, it's a safety issue. And so that was my primary concern, that, and then when he was burning last time, the smoke, it's so damp, and then that smoke would just follow the creek, and it was just suffocating when you went outside. So that's my concern. We addressed it last time about not dumping materials that he had brought in, and he said he wasn't bringing in materials to dump, but he brings in trucks full of materials and dumps them. If he's gonna start hauling that stuff off, then that's fantastic.
Okay, thank you. Hang on, I'm gonna let them speak and then we'll come back. Yep. All right, anybody else? Yes, sir.
Rick Jordan, 280 Robinson Lane. I just want to echo everything that Kristen Chilton said, and to emphasize for the board to review the agreements that were decided on a year or so ago when we met last about the hauling in, the work hours. Commend the, certainly don't want to put a small business out by any means, but I just kind of wonder what's going on. I mean, yesterday I drove by there was a dumpster delivery truck laying on its side. So bad stuff happens, but there's an environmental impact there as well that possibly was ignored. Thank you.
Okay, thank you. Anybody else?
Hello, my name is Keith Roark. I live at 100 Belvedere, so I'm on the other side of the road. I have noticed, like she said, that they made a great attempt to clean up the site. Fencing, building, all that stuff was all looking good. And then I come to find out that there's just a huge amount of debris piled over behind my neighbor's house. And we had agreed, I believe the last meeting I spoke with last year, that there would be no materials brought in off-site and dumped on that property, only what was on his property. Also with the burning was going down the creek into the neighbors' homes and kind of choking them out. So I think I made the great decision last year, or suggestion, that we move it east up closer to 460. Big failure. My house cars were covered in ash, and then my pool was full of it. So that didn't work out very well. Hours, the guys are, I knew when we talked about hours on a landscape business, there was no way they were going to be out there at 4:30. I've done landscaping in the past, and it just doesn't happen. Job's not always finished. But I do think there needs to be a reasonable time set in place that everyone is out of there, not slamming doors at 8, 9, 10 o'clock at night and screaming and yelling at each other to put the equipment up. And that's, you know, it goes on quite a bit out there because I sit out late at night on my patios. But going forward, I think my biggest concern is if we're talking about a permanent lease or permanent use of that property, what restrictions are going to be in place in the future? Because right now, everything seems like we're talking about temporary. Once a business is in full operation and we've granted permanent use of that property, what restrictions will he be abiding by? I think those need to be put in place and always followed, because there's nothing stopping a company from coming in after they've granted that use and just kind of do what you want to do. But other than that, again, just as they've said, I want to see small businesses succeed. But in doing that, you've got to state your word and stick to it. Thank you.
Anybody else?
Hello. My name is Zoe Zamora. I live at 131 Robinson Lane. I am the adjacent property. I've mentioned before that there were several conditions that I was concerned about. Primarily, that would be numbers 6, 7, 9, 11, and 12 that are mostly violated. Number 6 is the waste and material or vegetation that is unsightly. There are just large amounts of waste and materials that are there. I do appreciate the sight lines that are there with the trees, but the piles and mounds of the vegetation and waste materials are between the trees in my property, so I don't get the beautiful pines, I get all of that, and it's a significant amount, which now if you drive by it, that's all in the front part of the property, which has all been moved in the last 2 days. Number 7 is the 50-foot, anything needs to be 50 feet from the property line, which we heard in some other cases earlier today. The stacks of that debris is just right on the property line. It's not, it's directly there. Number 9 is the materials and vehicles outside of the floodplain. As we know right now, there's a lot of flooding that's happening on our property. And you can see a lot of those things are not being stored outside of the floodplain. 11, I already said the sightline barriers I appreciate, but again, yeah, it's not, yes. Number 12 is the time constraints, which Keith Roark referenced earlier. It's all hours in the morning, all hours at night, especially in the summertime. It goes very, very late into the night, which I do expect from a landscaping company, of course, because you're gonna have those long days, which I appreciate and respect. But if these are your conditions, then these are the rules that you're supposed to follow. And one of the things that I'm concerned about is, I had the same question, Sonia. You know, what makes me think that you're gonna follow the rules now if you haven't done that over the last 3 years since 2022. So, and I know it has been full 3 years, but one of the claims at one of our very, very first meetings was that the floodplain wouldn't be an issue and that the men could move it at a moment's notice, but you know, it's taken almost 3 days and there's still stuff that's stacked right on that property line. So, you know, if we actually did have a major flood come in, all of that would be in their driveway and right there. So that is a concern for me as well. I think I mentioned at one of the first meetings, you know, I'm really passionate about the earth and nature, and there's been some beautiful wildlife moments, and I know Keith and I have talked about, you know, getting to watch the deer out on that property. And I was very fortunate to get to see a mother deer, like, have a baby on my property, and they would come and visit and everything else, and it was awesome. And I came home one day and the men were chasing the mother deer towards the road. And that's just not okay with me on any front. So, you know, it's just, those are some of the primary things. We already talked about the burning, so I'm not gonna go over that again, but those are my primary concerns. And again, if the rules have not been adhered to up to this point, before there was even a business there, I'm just not confident that those are gonna be followed at this point.
Thank you. Anybody else? Mr. Franklin, your turn.
So, in regards to the vegetation, they're right, it's in the way. We are currently moving it from one location to another in order to get dumpsters in and get it cleaned up and no longer bring anything in. So to clarify, when Mr. Kane was here, I was under the assumption that I could not burn there, not just not bring anything in. So now I understand that I can't bring anything in at all, and I want to abide by that condition going forward. There wouldn't be a problem at all. Again, we'll take it to Rumpke, to the transfer station, and they take it to the landfill. In regards to the burning, I have not burned anything since the last time we were here and talked about burning. I have not burned anything. I have not directed anybody to burn anything. Not at all.
Well, was it the last time we moved the location of burning, and then he's having ash from that?
Well, we did that. Okay, so that was the board. That was, and Keith, I think you'll agree that we moved it over to the east side, I believe, for burning. And then when we made that decision, everything went to Keith's pool.
And so you did some burning at that point?
Sorry about that.
Just to clean up what I had accumulated then. But since then, nothing's been burned.
Correct.
And I will not burn anything.
I was just clarifying.
Yep, I will not burn anything. And again, everything's getting hauled off-site as of right now. The planning and zoning folks came out, like I say, Tuesday and looked at what I was trying to accomplish. I want to follow the rules. I want to be sensitive to neighbors. I've got debris on my property too from upstream as well. I understand that, and I don't want to be the cause for that. So I think with the 90 days that they give us, obviously I'm not burning, but let me get everything cleaned up and not bring anything in at all, just point blank period.
Go ahead.
Yeah, so you said nothing brought in, so the dumpsters, to just take it to Rumpke, you're not gonna bring it in and then take it to Rumpke, you're just using Rumpke for what's already there.
So for what's there, I bring in a dumpster. I call Rumpke, they set a dumpster. I fill it up, they take it away. Once that's all gone,
Okay.
I'll never bring anything in.
So no more pass-through, that's what I was-
Exactly. I'll take it straight there, which I've already started that process with them, and they're totally fine with me bringing wood there, brush.
Any other questions? Okay.
And I know one gentleman said that, the permanent thing, but, if I were to sell this property, this conditional use permit would go null and void, correct? Yeah, so what I'm wanting to do is exactly what is in the conditional use permit, which I want to abide by.
So here's the final statements I will make. Okay, so I'm a business owner as well. It is our job as a board to protect the business owners from a conditional use standpoint, but it's also our job to protect the neighbors that surround you.
Understood.
I'm going to be very honest with you. You didn't comply, period. Okay? I drive by your property every day, sometimes 10 times a day, depending on where my wife sends me, right? So I drive by all the time. The vegetation that was stored over there, you knew you weren't supposed to do that. I'm just being honest with you. That wasn't supposed to happen. Nothing in the floodplain, nothing over that way. You knew you were supposed to clean this up long before now. 2 days before this meeting, you started moving. That's unacceptable to me. I have one meeting left. I thought I had escaped all this, right? I have one meeting in March left. So you're going to send me out with a bang. So I appreciate that. Hopefully we don't have anything else come up in between now and then. Here's what I'm going to tell you. I agree with Holden. Holden was not here when all this started, but we've been talking about this man since 2022, right? That's 3 years. I agree that there should be a time period to allow you to do that, but I know how long that takes to move debris because I've moved 58,000 cubic yards of dirt in the last 6 months. I'm going to give a time period of 30 days, and it's not 30 calendar days. Actually, I'm going to change that. By the next meeting that we have, because I don't want to leave this board with this over top of their head. I'll deal with it. Okay? You have between now and the next meeting to come into complete compliance, all of it. If it is not, we will revoke your conditional use permit at that time. Agreed?
Yes, sir.
All right. Anybody else got anything to add?
And then it stays in compliance.
And it stays in compliance from that point on.
Agreed.
Agreed?
We need a motion to that effect.
I will make a motion that you have until the next meeting to bring all items in compliance, or you understand that your CUP will be revoked at that time.
Yes.
And you will stay in compliance from that time on.
Yes.
Okay? That is my motion. Do I have a second?
I'll second.
Ms. Holland seconds.
Okay.
Any questions or comments? All approved by saying aye.
Aye.
All opposed by the same. There are none. Motion carries. Anything else? All right. At this time, meeting is adjourned at about 6:12.